Friends, let me tell you what has happened in the Mahesh Negi case. Mahesh Negi is an MLA from Dwarahat. He has been accused of having had an affair with a woman from Dwarahat who was subsequently married, and then she had a child. The DNA of the child did not match that of her husband's, and she has now separated from him. She has accused the MLA of fathering the child and is demanding that a DNA test be done, which is being refused by the MLA. In fact, he told her that he would commit suicide if he had to do that. After that, the wife of the MLA is supposed to have met the woman, and now the problem is that she has registered an FIR against this particular woman. The wife has registered an FIR against this particular woman, saying that she is trying to extort 5 crore of rupees. After that, the woman was called to the police station, saying that she had to undergo a COVID test and she had just returned from her in-laws' place in Shamli near Meerut. But she was taken to the police station, she was questioned, she was interrogated, she was told, she was asked basically as to what she was planning to do. After that, when she went back home, she's got a 3-month-old child. When she went back home, she made a video and she posted it on Facebook. After that, it went viral. Everybody got to know, and the police was supposed to be registering an FIR. Now, isn't this a cognizable offense? Are the two accusations similar? No, not at all. The wife of the MLA is accusing this woman of blackmail and extortion. Why would this woman blackmail or try to extort money from them? Obviously, there has to be a reason. The reason obviously is that she's got this child and she's demanding a DNA test. And on the other hand, the police, which is not registering the FIR of the woman, is saying that this matter has been clubbed with the woman's matter. It is mandatory for the police, as per the directives of the Supreme Court, to register this FIR. If they do not do it, they are committing a criminal offense. And let me tell you about this case. Yes, this writ petition was filed in the High Court. Okay, let me tell you the decision of the Supreme Court in the 2014 case of Lalita Kumari versus the government of Uttar Pradesh, where they summarize the law in connection with registration of crimes. The registration, I'll tell you point-wise, the registration of an FIR is mandatory under section 154 of CRPC if the information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such a situation. The second point here says that if the information received does not disclose a cognizable offense, but if the accusation is that of rape, it is a cognizable offense. But indicates the necessity for an inquiry. A preliminary inquiry may be conducted only to ascertain whether a cognizable offense is disclosed or not, right? If the inquiry discloses the commission of a cognizable offense, the FIR must be registered. The cases where preliminary inquiry ends in closing a complaint, a copy of the entry of such closure must be supplied to the first informant forthwith and not later than 1 week. It must disclose the reasons in brief for closing the complaint and not proceeding further. A police officer cannot avoid his duty of registering an FIR if a cognizable offense is disclosed. Action must be taken against erring officers who do not register the FIR if information received by him discloses a cognizable offense. The scope of preliminary inquiry is not to verify the veracity of otherwise of the information received, but only to ascertain whether the information reveals any cognizable offense. Now, you know what this means? This clearly means that there has been a cognizable offense which has come to the notice of the police, but they're not registering an FIR. The reason is the MLA, who is in a powerful position. He's supposed to be a very powerful person. If the allegations are proved wrong, the police can always file a closure report. Then why are they not registering an FIR? Let me tell you why. In 2013, there was a three-judge Supreme Court judgment, according to which this is a non-compoundable matter. Yes, non-compoundable. What does it mean? That if an FIR has been registered and the accused and the complainant, they come to some kind of compromise, some kind of settlement between them, in cases such as rape, etc., then the police cannot afford to say that they will not take the case forward, or they will not file a charge sheet, or if the matter is in the court, they cannot request the court to to close the case. The case cannot be closed because this is a crime against the state. And this judgment was given by like I said, a three-judge bench. Who were the justices there? Justice Sadasivam, Justice Ranjana, Justice Ranjan Gogoi. And this was a judgment which was passed in 2013. And so do you understand that this is a non-compoundable offense, because of which the police is under pressure to ensure that they do not register an FIR right now, because they will obviously try to get the woman to compromise or come to some kind of a settlement with the MLA. That is the reason why this FIR is not being registered. In addition to that, let me also tell you that there is another complaint which has been given by the victim, because the wife of the MLA gave in a complaint where she has said that the child is facing a threat from the victim and her family, meaning the accused in the case of in this particular case. So the wife of MLA Mahesh Negi in her complaint has said that the 3-month-old child is facing a threat from her mother, that is the lady who she has accused of extortion and blackmail. She is saying that that child faces a threat from her mother and her family. That is what this lady is saying. I do not know what is the truth and what is not. I am simply informing you of this particular complaint which I came across, which was given in by the woman who is accusing the MLA of rape. Whether rape has been committed or not is a different issue altogether. If the woman is asking for a DNA test to match it with her daughter, don't you think that that should be done? Since this is a question of an MLA. If we want to clean up politics, we must demand that politicians are clean as well. And they need to come clean. They need to ensure that they come before the police, undergo the procedure as per law. If the FIR of the wife of Mahesh Negi has been registered, the FIR of the woman should also be registered. It clearly shows that laws are different in our country for different people. For an MLA, it is different. For a common person, it is different. But let us hope that now that the MLA is supposed to have appeared before the police, though he apparently came in the dead of the night to give his statement, let's hope that things come to a close. Another very important point. The woman, both an accused and a victim, is a woman. We need to be gender sensitized for the simple reason that when the matter relates to that of a woman and the woman is accusing the MLA of rape or of fathering her child, it's a sensitive matter. It's a heinous crime against a woman. Rape is a heinous crime against a woman. And who should be investigating this matter? A woman? But no. Initially, the case where the wife of the MLA had accused this woman of extortion and blackmail was being looked into by an investigating officer who was a man, and now this particular case has been transferred to CO Sadar, and he is also a man. There are too many mistakes happening here. Let's raise our voices and demand that the government ensures that the police is not under pressure and there is a fair investigation in this matter. That is how we will ensure that politics becomes clean.